just continues to get more and more damning as Helena Silverstein proceeds in her book. I mean, misconduct. Sorry, I'm hungry. A possibility always exists, of course. The legitimate executive objectives of any law or legislative program may be subverted by conscious design or by lax enforcement. We have seen that ignorance impedes access to the bypass route, but barriers exist even when officials largely unaware, even when officials are largely aware of their responsibilities. In this chapter, I address two such barriers: administrative malfunction and defiance of the law. Minors who seek to waive parental involvement face obvious time constraints. The window for obtaining an abortion is narrow. It begins with knowledge of the pregnancy, which often comes weeks after conception, and acknowledging, according to the American Academy of Pediatrics, teenagers are twice as likely as adults to delay the diagnosis of the first trimester of pregnancy. For practical reasons, the windows for obtaining an abortion without parental knowledge may all but close with the onset of the second trimester. Most obviously, the longer it takes to secure an abortion, the more likely it is that parents will discover their daughter's pregnancies. Furthermore, later term abortions pose greater health risk that may prevent a minor from having an abortion or that may influence judicial decision making concerning whether an abortion serves a minor's best interest. Additionally, a minor whose pregnancy has advanced beyond the first term may confront the challenge of locating an abortion clinic that provides second trimester abortions, or may find the abortion to be prohibitively expensive. Recognizing these time pressures, the Supreme Court has held that bypass proceedings must assure that a resolution of the issue and then any appeals that may follow will be completed within sufficient expedition to provide an effective opportunity for an abortion to be obtained. Following this directive, state legislators have included statutory language that demands the expedited handling of bypass petitions, as discussed in Chapter 2. Both Alabama and Pennsylvania require trial courts to rule within 3 business days of the time the petition is filed, with Tennessee mandates that the juvenile courts would reach its decision within 48 hours of the time of the application. With only one minor linguistic variation, the laws in Alabama, Pennsylvania, and Tennessee stipulate that the court's proceedings shall be given such precedence over pending matters as is necessary to ensure that the court may reach the decision promptly. Though attentive to time pressures, once a petition has been filed, these statutes do not address how quickly the courts or court advocates must respond to those seeking information to file a petition. But it's clearly not enough that the courts handling the hearing itself within a narrow time frame. It also matters how promptly minors can navigate the bypass process, and that in turn depends on how quickly they can obtain information from authorized parties. It is easy to idealize the functioning of the judicial bureaucracy to suppose a seamless transition of word into action. So we might imagine if the state allows a minor to petition a court for a waiver of parental involvement, the minor will be able to pick up the phone, make 1 or 2 calls, and reach someone who will tell her what to do. As we have already seen, this is far from the case. In fact, a minor is likely to reach someone who does not know what to do, and as we shall see below, access to potentially helpful parties may be impeded by things such as court employees who are in court, out to lunch, or otherwise away from their desk, court advocates who are unavailable due to meetings, vacation, or sick leave, busy signals, voicemail recordings, and so forth. Furthermore, delay is sometimes caused by judicial gatekeepers who may well send minors off in search of wild geese. The remainder of this section exposes how these administrative challenges, beginning with the Beginning with the hurdle of reaching a knowledgeable court employee in a reasonable time period and without repeated phone calls, I then turn to bureaucratic inefficiencies that hamper operation of the Tennessee court advocate system, courts. In Chapter 3, it presented the court employee responses that can coincide with our expectations concerning the provision of information. Specifically, we found employees in 34 of Alabama's 67 counties, 16 of Pennsylvania's 60 judicial districts, and 44 of Tennessee's 95 counties who seemed prepared to implement the bypass process in an appropriate manner. To ascertain the ease on which a minor would gain access to these employees, we tracked the number of calls. We tracked the number of calls placed during our inquiries. We found that access to these officials was often problematic. It would be easy to artificially inflate the number of phone calls by, for example, calling outside of business hours or redialing the same number immediately after encountering a busy signal. To avoid this, I only count the calls placed to the same number if those calls were placed more than 30 minutes apart, unless we were otherwise directed by a respondent to call back at a particular time. In addition, and again, unless otherwise directed, I count no more than 3 calls to the same number in a single day. We made calls during regular business hours, and the counts presented below do not include any initial calls one might make to directory information. I do, however, count calls made in those instances when we came across the wrong number or number that was out of service. Provided that we found this number, provided that we obtained the number through official channels. Here is an example of a case from Tennessee in which it took 6 calls over a period of 2 days to get an appropriate response from the court. Tuesday, May 21st, 2002, 2:05 p.m. CST, calling the juvenile court employee, CE, juvenile court, researcher, who is referred to as R. I'm calling to find out how a girl who is not 18 who wants an abortion can get a judge's permission to avoid telling her parents. Court employee, Hun, I don't know. You would probably need to come in. I don't think the judge would do that. I don't think he would. Let me get your name and number. Researcher, can I call back? Court employee, well, is this a juvenile or what? Researcher, excuse me? Court employee, how old are you? Researcher, I'm just trying to get information about this. Court employee, let me give you this number. Hold on. I'll get a number for you to call upstairs, but hold on. I'm going to check first. Pause, ma'am. You need to come up here and talk to someone. The lady you can talk to is Miss Burgess. Tuesday, May 21st, 2002, 2:30 p.m. Calling Miss Burgess. No answer. Wednesday, May 22nd, 2002, 1 p.m. Calling Mrs. Burgess. Court employee, juvenile services. Researcher, can I speak with Miss Burgess? Court employee, she's not in. She'll be back in about 20 minutes. Wednesday, May 22nd, 2002, 2:13 p.m. Calling Miss Burgess. Court employee, juvenile services. May I speak with Miss Burgess? CE, she hasn't got back then. Do you want her to call her back? Researcher, no, that's okay. Court employee, try back in about 15 more minutes. Okay. The researcher replies. Wednesday, May 22nd, 2:50 p.m. Calling Miss Burgess, juvenile services. May I call Miss Burgess? May I speak with Miss Burgess? She'll be back in about 15 more minutes. Wednesday, May 22nd, 2002, 3:10 p.m. Calling Miss Burgess. CE, juvenile services. Researcher, may I speak to Mrs. Burgess? Court employee, this is she. Researcher, I called yesterday to find out how a girl who's not 18 who wants to get an abortion can get a judge's permission to avoid telling her parents. CE, hang on 1 second. I have a procedure on that. Okay. There is a 1-800 number. It's 1-800-435-7495. And the juvenile court will hear the case, but it goes through the Department of Children's Services and they facilitate. There will be an advocate for you. We're reminded to receive this response, she would still have to make another call to the DCH hotline to get the advocate's number and place at least one phone call and possibly many more to reach the named advocate. Nevertheless, we had some reason to believe that the persistence would pay off, as our courthouse was generally helpful during the initial call. The same cannot be said for the following attempt to reach an Alabama court, which took 10 calls on 4 separate days. October 10th, 2001, 9:45 a.m., calling the juvenile court, no answer. Again on the same day at 10:42 a.m., no answer. Same day on October 12th, 2001 at 12:25 p.m., no answer. Friday, October 12th at 2:03 p.m., no answer. Monday, November 5th at 12:13 p.m., calling the juvenile court, no answer. After 5 failed attempts and no voicemail guidance, we located a second phone number for this juvenile court. The following calls were placed to that number. Monday, October 15th, 2001, 12 p.m. at 15 p.m. Calling the juvenile court, voicemail. We're not here now. If you'd like to leave a message, press 2. Monday, November 5th, 15th, 2001, at 1:30 p.m. Calling the juvenile court system, voicemail. We are not here right now. Wednesday, October 17th, 2001, 9:17 a.m. Busy signal. October 17th, 2001 at 9:58 p.m. Busy signal. Wednesday, October 17th, 2001 at, oh God, at 11, calling the juvenile court, CE, court employee, researcher. I'm calling to find out how a girl who is not 18 who wants to get an abortion can get a judge's bypass, a judge's permission to avoid telling her parents. Court employee, you're asking to be, hold on one second, pause. The best case scenario is a petition is filed, the guardian ad litem is appointed, an attorney. At that point, you're going to have to do it through the court. This is confidential. The individual would have to come up here to the office and would have to start the process. Consider as well another protracted effort to gain information from the court employee in Alabama. Here we took 12 phone calls and a substantial runaround before we come back full circle to where we had begun. Wednesday, October 10th, 2001, 10:52 a.m. Calling the juvenile court. Voicemail. You've reached the juvenile courthouse. We're sorry we cannot answer the phone. To speak to Mrs. Reinhardt, call XXXXXX. To speak to Mr. Vinkar, call XXXXX. To speak to Mr. Falbo, and then the same thing. Wednesday, October 10th at 11:22 a.m. Voicemail, same as above. They call again and again and again, October 10th, 2001 at 11:23 a.m. Voicemail. They call all of these guys and they call all of the guys that were listed there and they get voicemail. They call the juvenile court again. They get voicemail, and then they call Mrs. Falbo again and get voicemail. And then finally, on October 12th, 2001 at 3:39 p.m., they called Mr. Venture, court employee, juvenile court. I'm calling to find out how a girl who is not 18 and wants an abortion can get a judge's permission to avoid telling her parents. Court employee, you'd have to talk to a lawyer or talk to somebody in probate court. Researcher, do you have a number? Call Judge Boslow, probate court. So they call Judge Boslow, Judge, county courthouse. Researcher, can I speak to Judge Boslow? Judge, this is she. I'm calling to find out. The researcher then responds, I'm calling to find out how a girl is not 18 who wants an abortion can get a judge's permission to avoid telling her parents. Judge, that's to the circuit courts, Judge Miller. On Thursday, October 11th, 2001 at 3:46, calling Judge Miller, CE Circuit Court. Researcher, I'm calling to find out how a girl who is not 18 and wants an abortion can get the judge's permission to avoid telling her parents. Court employee, that has to go through the juvenile court. I can give you the number. Researcher, I already called there and they said to call Judge Boslow and she said to call you. Court employee, well, it doesn't happen that often, but it goes to the juvenile court. Let me call them and why don't you call me back in 10 minutes? Thursday, October 11th, 2001, calling Judge Miller. Researcher, hi, I called a little while ago. Court employee. I talked to the juvenile officer. His name is Miss Windsor. I think you already have their number, but it's, here they give the number. Thursday, October 11th, 2001, at 4:12 p.m. Calling juvenile court number. Court employee, this is Mr. Venture. Researcher, I spoke with you earlier. I'm still trying to find out how a girl who's 18 who wants an abortion can get a judge's permission to avoid telling her parents. Court employee, that's what I'm reading up on. This is all new to me. I went and talked to the judge. What I'm trying to do right now is read. A minor who elects to not to seek or does not or cannot for any reason obtain consent from either of her parents or a legal guardian may petition on her own behalf the juvenile court system or the court of equal standing in the county in which the minor resides or in the country in which the abortion is performed for a waiver of the consent requirement of this chapter. So first of all, there would be need a waiver of consent. The number of phone calls required to reach a court official is useful, but an imperfect proxy for measuring the magnitude of the barrier for information. For example, in one of the larger counties in Alabama, it only took 3 phone calls to elicit accurate information. However, our first contact with the juvenile court indicated that the person who handles the bypass inquiries would be unavailable for a week, and that no one else could provide information about the process. Overall, and putting aside the number of days it may have taken to reach a helpful office, it took 5 calls to reach one of Pennsylvania's willing and able courts, and fewer to reach the remaining 15. For Alabama, it took 5 or more calls to reach 9 of 34 such courts, and in more than half of these instances, it took between 7 and 12 calls to reach someone who offered an appropriate response to our query. We placed at least 5 calls to reach 13 of Tennessee's 44 prepared courts. Indeed, in 6 of these cases, we placed between 8 and 17 calls. Court advocates. As noted previously, Tennessee has specifically made it someone's job to guide minors through the bypass process. There's even an 800 number to reach the escort service and a brochure that lists the direct numbers for the escorts themselves. Nonetheless, we repeatedly encountered difficulties in our efforts to reach DCS advocates. Often, the reasons for delays in reaching advocates mirrored those encountered in attempts to contact court employees. Busy signals, voicemails, etc. Incorrect or outdated information in the DCS brochure or provided by the toll-free hotline also contributed to some of those delays. Additionally, because most advocates serve multiple counties and hence have multiple offices, they could not always be tracked down easily. The following effort to reach an advocate illustrates a combination of obstacles that can create considerable delay in accessing information. Friday, June 14th, 2002, at 3:16 p.m. Calling DCS advocate Linda Cornett. DCS Children's Services researcher. May I speak with Linda Cornett? DCS, hold on a minute. It doesn't look like she's here. Would you like me to take a message? Researcher, I'll call back. Do you know when she might be in? DCS, I don't really know who she is, so I don't know. This is just ongoing. Like, Monday, June 17th, 2002, at 3:11 p.m. Calling DCS advocate Linda Cornett. DCS Children's Services researcher. May I speak with Linda Cornett? DCS, I don't believe she's in this office. Hold on, man. You can try her at, and then they list the number. She's based in Centerview. She's sometimes in this office, but she's mostly in the Centerview office. Now we tried. Monday, June 17th, 2002, calling DCS advocate in the Centerview office. DCS Children's Services researcher. May I speak with Linda Cornett? DCS, Linda is in Hampton County today. Researcher, do you know when she'll be in? She should be in tomorrow. Should I call again the next day, Tuesday, June 18th, 2002 at 3 p.m. Calling DCS advocate Linda Cornett in the Centerview offices. DCS Children's Services researcher. May I speak with Linda Cornett? DCH, hold on, transfer. CA, this is Linda. Researcher, I'm calling to find out how a girl who's not 18 and wants to get an abortion can get a judge's permission to avoid telling her parents. DCH, okay, well, I'm not the person who does that anymore. Her name is Pam Bonden. Pam would go over everything. Her number is, and then they list it. Tuesday, June 18th, 2002, 3:02 p.m., calling DCS advocate Pam Barnett in the Centerview office. Voicemail, you've reached the office of Pam Barnett. Leave a message and I'll get back to you. Wednesday, June 19th, 2002, 3:07 p.m., calling DCH advocate Pam Barnett in the Centerview office. Voicemail, Wednesday, June 19th, 2002 at 4:27 p.m. Calling DCS advocate Pam Barnett in the Centerview office. Voicemail. They try again the next day at 3:37 p.m. Voicemail. And then finally on Tuesday, June 20th at 3:38 p.m., they call the main number for the Centerville office, Children's Services. DCS answers, Children's Services. Researcher, I'm calling for Pam Borden, but I've called her several times and I've only got her voicemail. Do you know if she's around? DCS, she's just passed me with her phone, so we don't know what the problem is. Researcher, so she's there. DCS, she went to someone else's office. Do you want me to take a message? No, I'll call back. Thursday, June 20th, 2002, 4:53 p.m. Eastern, calling DCS advocate Pam Borden in the Centerville office. Finally, we get the CA. This is Pam. Pam went on, after some initial stumbling and hesitation, to provide the appropriate information on how to pursue the waiver route. But arriving at this information took 10 phone calls placed on 5 separate days. Part of the little a in this case, a total of 4 calls, came as a result of a DCS brochure that had not been updated to reflect the change in designated advocate. But at least DCS had in fact designated a new advocate to replace the former advocate named on the brochure. We did sometimes find that the counties were simply not served by court advocates. In these cases, the brochure and hotline referred us to former DCS employees, current DCS employees who no longer serve as advocates, or advocates who were unavailable. In each of these cases, our efforts to gain advocate assistance from DCH failed. In one case, upon calling the number for the designated advocate and learning that the advocate was unavailable to do extended sick leave, we posed our standard inquiry to the DCS employee who answered the phone. We received this response: you've got an underage child wanting to get an abortion. I don't know how to do that lawfully. Hold on a second. Let's ask our department is not allowed to advise an abortion. You'll have to call the health department. Jesus. In the second case, after 7 unanswered calls placed to an advocate, we sought information from each of the local DCS offices that operate in counties served by that advocate. These offices could provide no information about the waiver option or the role of the advocate. In the third case, after repeatedly failing to reach the court advocate, we were transferred to a DCS attorney. The attorney knew about the bypass option and explained that court advocates assist minor through the process. However, his best advice was to contact another county. Basically, each county is supposed to have a contact person, and we used to have a contact person in this county, and she retired. So that what we're told is the person that has to do this on this point is contact a person in another county, and that they could assist because they were in the same department. So someone in another county could help. We received a similar response in a fourth case from a DCS employee who used to function as an advocate, despite the fact that this employee was referred to the procedure and referred to in the brochure and by the hotline. She explained, "I'm kind of out of that right now. I don't think they've assisted anybody to take my place. Lacking information on who might assist a minor in the county she formerly served, this respondent recommended phoning an advocate assigned in another county." In a fifth case, we were again referred to an advocate in a neighboring county, having been told that the previously designated advocate no longer worked at DCS and had to be replaced. As was our practice, we took the advice we received in these last 3 cases and called the advocates to whom we had been referred. In 2 instances, we reached the recommended advocate, but the advocate indicated that she would only handle waivers in her designated counties. In the third instance, we referred to the recently retired advocate. The availability of the court advocate system does not alleviate the challenge of actually getting through to an advocate. The brochure distributed by DCH listed contact information for 28 advocates assigned to serve Tennessee's 95 counties, but as we have just seen in 5 cases covering 14 counties, we failed to reach the allegedly designated advocate and found no one willing to provide services in those counties. We succeeded in reaching 23 advocates who were designated to serve 81 counties. As discussed in the previous chapter, all but one of these advocates were able to provide satisfactory information, but in 8 cases, we succeeded in reaching informed advocates only after placing between 5 and 13 calls, not including any calls that were made to court personnel who may have referred us to these advocates, and employing the same restrictions on the counting above. Defiance. Now we get to the judicial misconduct part of things. The administrative inefficiencies described above and the ignorance described in Chapter 4 largely account for the gap between what we expect from the bypass process and its actual functioning. And there are still other factors. In Judicial Policies, Implementation, and Impact, Bradley C. Cannon and Charles A. Johnson identify non-acceptance as a response to court rulings. 17, there's a footnote. Persons who do not accept a judicial policy are likely to engage in behavior designed to defeat the policy or minimize its impact. They will interpret it narrowly, try to avoid implementing it, and refuse or evade its consumption. Several courts have demonstrated that familiarity with parental consent provisions displayed such non-acceptance. In some instances, non-acceptance was manifest not in terms of refusal to comply with legal mandates, but in expressions of opposition to abortion as similar to those that we saw in Chapter 4 made by ignorant respondents. As Cannon and Johnson explains, not every non-acceptor will be in the position to ignore a decision or simply refuse to comply with it. People may adjust some of their behavioral responses to meet with the decision's requirements, while they have another, less visible behavioral responses that may more truly reflect their unwillingness to accept the decision. Consider the following remark made by a woman in the Pennsylvania Court Administrator Office who obviously knew what to do when queried about the bypass process. She said, "I know this is business, but I can tell you that it's very stupid. It's a very stupid thing to do, and that you have to live with it for the rest of your life." Hold on. Pause. The woman you need to talk to is out of the office right now. She'll be back tomorrow. In other instances, we found non-acceptors who, while processing sufficient knowledge to implement the bypass procedures, appeared ready to ignore or just outright defy the law. We encountered a total of 8 such instances in our contact with county courts, 2 in Tennessee and 6 in Alabama. In each court, employees noted the judicial opposition a minor would confront were she to seek to exercise her right to file a petition. In Tennessee, 2 court employees indicated that judicial consideration of waiver requests would almost inevitably result in a denial of those requests. According to one of these employees, usually you have to appear before the judge, but given the circumstances, it's up to the judge's decision. Usually the judge does not sign for a juvenile to have an abortion. That's just something he chooses not to do. One of the other judges in the surrounding counties may give her consent, but it would be kind of iffy here for the judge to give consent. It's a hard decision for anyone to make, and so it's a difficult decision to make. The judge is pro-life, and that makes it more difficult for him to sign a consent form. In the second Tennessee County, court employees stated unequivocally that the judge would not sign the minor's request and to avoid parental involvement in abortion. Asked why the judge would not sign, this employee simply said he does not believe in abortion and further offered advice for that pregnant minor. She needs to think about some alternative other than that. A lot of people want to adopt children. In fact, I have 2 adopted children. The judge has an adopted child. There are plenty of people who want to adopt children, so she needs to think of other alternatives. Several Alabama respondents made comparable remarks about the judicial attitudes against abortion or the bypass option. Among these 2 recommended that a minor seek her bypass elsewhere because of the judicial opposition. One explained that minors have the legal right to file a confidential petition to waive parental consent, but said, "I can 100% guarantee you that they will not grant the petition. The family court does not believe it is an issue that should be decided by the court. The judge will not grant it. It's the judge's decision, and he will not grant it." Asked whether all judges in the county would deny it and I'll bypass, the judge offered, "That is correct. That's what we pay them money for, to judge and rule over cases, and the judges here will not allow that proceeding to take place." He further cautioned that if a judge denied a bypass petition, the minor would not be able to file elsewhere. They'll have to file in the county that the abortion procedure is done. My judge is going to say, I will deny it. I don't grant it. So you can't take it to another court. She'll need to find a county that performs an abortion and contact the juvenile office there and the clinic there. And they're set up. They're set up to do it. The juvenile probation officer in a second Alabama court reacted similarly, in both conveying judicial hostility to abortion and an advising pursuit of the bypass petition elsewhere. She has to petition the court. She has to come before the court and ask for a petition, but I can promise, unless you have some serious medical condition, it won't be granted. My judge is anti-abortion, and he doesn't believe in a child should have done this without her parents. You have the right to file, and you have the right to file in your initials. Your name won't even be on the petition, but that doesn't mean he will grant it. We had one case one time, and the doctor advised her to have her abortion for medical reasons, and the judge still would not grant it. Do you know what that if you're attempting to have the abortion in Jefferson County, you can go to Jefferson County to the judge. I know they will grant it there. They're going to say, do it in your county, do it in your county, but you have done it, but you can have it done there. The odds are real slim there. In another 4 counties in Alabama, respondents made it clear that judges would not hear petitions. One respondent said that while a minor could file a petition, in the county's juvenile court, the judge would transfer the case to the case where the abortion would refer. Usually they get it transferred up to Montgomery. Our judge here usually recuses himself from those types of hearings. He just requests a transfer of venue because he doesn't do those types of hearings. We change of venue. The respondent further explained would require the minor travel to a new venue for the hearing. Another Alabama respondent simply said, we don't do that here in this county. You'll have to go to Jefferson County to get that judge. Our judge doesn't do it. He doesn't believe in it. Mirroring this reply, yet another said, we don't do this in this county. My judge says to do it in the county where you were getting the abortion. Whatever, we've had people asked to do this. Most of them from here go to Tuscaloosa, the juvenile court there. We don't file those in this county. It says it can be done in the county where she lives or in the county where the abortion is performed. My judge won't take the case. He said he's not going to get into that here. My problem is not notifying the parent of it. Still, another Alabama court employee gave this explanation for judicial avoidance of the bypass process. You can have it done in the county that you live in or the county that the abortion procedure is going to be performed. The judge wants the person to do it in the county that they are going to have the abortion done in. We haven't had it done here because he doesn't want to do it here. It's a small place, and there's a lot of stuff that can arise from that. He wants her to do it in the place where she's going to get the procedure done. It's just that he doesn't want to do it here. He, being the judge, is not going to order something like that to be done. Echoing court employees in Alabama and Tennessee, some DCH advocates made reference to judicial unwillingness to handle bypass cases. One advocate who accurately described the details of the bypass process said, we'd go to a judge and see if he's willing to do that, and if not, shop around. They don't have to do it. It's not compulsory. There are judges who do it, but there are many judges who don't believe in that and don't do it. Ask what happens when a judge doesn't do it, the advocate replied. Then you have to shop around in the state of Tennessee and see if you can find one. The following exchange with another advocate further alluded to the judicial opposition to the bypass route. Court employee, the advocate, if you want to do this and you don't want your parents to know, you file a petition in the juvenile court, and you can go to any county. I don't think they will. If you want to know the truth, I don't think they will do it here. I've never had one, so I don't know for sure. I can give you the name of a person in another county who knows what to do. They file a petition for you. You go to the court. This is called a judicial bypass. If you want a lawyer, they'll appoint a lawyer for you, so you don't have to pay for anything. But if you don't want a lawyer, that's fine. If you're denied, they can appeal it, but it's a real quick situation. And what I do is give them a name, a number in another county, because it's a one-day thing. And these people do this all the time. Is it likely that she would get permission? The advocate, oh yeah, they do it all the time over there, but the judges up here feel very differently. So you don't think one of the judges here would do it? See, court employee, the advocate says no. If it's in one of the counties I serve, I can tell you the judge won't do it. The judge has said he would not want to do it. I've had another from another county when he found out that it can be done, and another county said, good, I don't want to do it. In these small rural counties, they feel very strongly about it. In the above instances, we see indications of non-acceptance of legal mandates that would amount to judicial defiance of the legal obligation to afford minors access to authorized venues for bypass hearings. My only question is why somebody hasn't turned these people into the bar association for and other organizations for judicial misconduct, because this is clear and misconduct. This is not to say that all judges must hear bypass petitions regardless of their views about abortion. Where a conflict of interest exists, judicial recusal is not only permissible but may be required. However, there is debate over whether judges may, consistent with codes of judicial conduct, recuse themselves from an entire class of cases. Blanket case recusal, whether in bypass hearing or in cases involving such morally charged issues as is the death penalty, euthanasia, divorce, and so forth, may signal not simply a conflict of interest, but an unwillingness to comply with the law. Such wholesale recusal, some legal ethicists argue, amounts to judicial nullification of the law and is therefore improper. Whatever resolution of this debate, courts can at the very least handle recusals in a way that respects a minor's entitlement to have her petition heard in the designated venue. In fact, some respondents illustrate how this can be achieved. Consider the following exchange with an Alabama court employee. I talked with her judge, and the procedure is that she needs an attorney. If she cannot afford an attorney, she needs to come to the juvenile court and fill out an affidavit of hardship. All of the procedures are confidential. The affidavit would be given to the judge to approve. Then the judge will appoint an attorney, and she will need to talk to an attorney to prepare the paperwork. I have a couple of other questions about the procedure. The researcher replies, I'm probably not going to be able to answer those questions. I got my information from the judge, but he'll probably recuse himself. My judge won't handle the case. He won't handle it. Researcher, why? Because he doesn't feel comfortable. I don't know how to answer that question, but he doesn't feel comfortable. Researcher, but someone else will handle it? Court employee, yes, another judge from another county will handle the case. Researcher, in this county, yes. Researcher, how long will it take? Court employee, well, to be honest, if they go and fill out all the forms, I have an out-of-town judge coming. That would be this Wednesday. They can go ahead and get their affidavit prepared, and they would have someone here on Wednesday to intake the paperwork, and then I will call the judge and ask him how I need to proceed. He may set it for Wednesday. He may set a separate date. He has a lot of things scheduled this Wednesday, and it may be hard to keep confidentiality down with all the people here on Wednesday, but this judge has done the procedure here for us before. The response differs from those in which opposition towards abortion of the bypass process leads to unwillingness to ensure the availability of an authorized venue for the disposition of the bypass request. Here, the respondent made it plain that the recused judge would be replaced by another judge when the courts fail to do this, and instead place the minor in charge of traveling to another county in search of a willing judge. The minor may well succeed in her search to successfully file her petition elsewhere, but the possibility does not remedy the fracture caused by judges abdicating in their duty to afford minors the right to an impartial judicial hearing in their home counties. The conclusion. There is little that can be done to trace the actual effect on pregnant minors of the ignorance and misconduct we observed in our efforts to gauge access to the bypass route. We can, though, try to place ourselves in the shoes of a pregnant minor in order to envision the consequences of the implementation failures reported here. Consider first the pregnant teen who has learned from a sister, a friend, a school nurse, an abortion provider, or news reports that there's supposed to be a method in place for securing a waiver of mandated parental involvement. Were this minor to contact her county court system and confront, as we did, uninformed, inaccessible, or defiant court personnel, she may justifiably react in ways that undermine the entire point of the bypass compromise. Imagine, for example, a minor who, on the advice of the court, contacts a crisis pregnancy organizations that, as we have seen, are useless with regard to obtaining a bypass. Imagine further that this advice is accompanied by such sentiments as the parents are ruling over her, so a judge can't rule on that. And I don't think a judge would talk to you about that. I don't think anyone here would talk to you about that. Or suppose the minor is told that she can come read the local rules and figure out how to write a petition, or is simply advised to seek an abortion out of state. In each of these cases, a pregnant minor would have good reason to abandon her efforts to pursue the bypass route, an effort, let us not forget, that is enshrined in state law and blessed by the Supreme Court. Consider also the minor told by court personnel that she would need to get an attorney by legal aid they could not help, or by lawyer referral service that she would have to pay for counsel. Again, it's not difficult to imagine that a minor may simply give up her request for a bypass in this set of circumstances. Even in cases where the courts are potentially ready to offer a hearing, their responses could discourage a minor from further pursuit. In the best of circumstances, a minor would have reason to be apprehensive about the prospect of going to court for a hearing. Indeed, Dr. Jane Hodgson, plaintiff of the Supreme Court case Hodgson versus Minnesota, testified that when her minor patients returned from the court processes, some of these were wringing wet with preservation. They're markedly relieved. Many of them, they dread the court procedure more often than the actual abortion procedure itself. Given this already heightened anxiety, would a minor be likely to persist after a judicial representative says, I know this is business, but I can tell you that it's a very stupid thing to do and you would have to live with it for the rest of your life? Would a minor actually go to the courthouse to fill out the papers when no assistance or even basic information is offered over the phone? In the face of such resistance, it would not be surprising if a minor were dissuaded from pursuing a hearing. Everything about the system is set up to, discourage people from actually doing it. Now, the minor would abandon her efforts for a bypass in the face of these various scenarios is all the more likely given the misinformation or defiant remarks that would be coming from authoritative representatives of the judiciary. Information offered from official court personnel holds authoritative sway. Moreover, a minor is unlikely to have the knowledge required to challenge this information or the gumption to persist in the face of resistance. If a court employee or administrator says, I have the rules right here and there's nothing on this, a minor might believe him or her even if she has heard otherwise. For a minor to altogether give up on the possibility of gaining a judicial hearing, she would be left with few good options. She might travel to a nearby state that does not require parental involvement if one is within reasonable reach. At present, this option is challenging enough, for the distance a minor must travel to such a state may well be substantial. Alabama, for example, is now surrounded by states that require parental involvement, and a minor would have to travel as far as Illinois to find a state that does not impose this mandate. In the future, this option will likely become all the more challenging as states continue to join the ranks of those who have adopted involvement mandates. In addition, both houses of Congress have passed bills to criminally sanction those who help minors obtain abortion out of state if such aid would constitute circumvention of the parental involvement mandate. If this becomes law, a minor who seeks out-of-state abortion to avoid parental involvement would be forced to make this venture on her own, or she would be put on a friend, or she would put on a friend or relative than the risk of going to jail. Perhaps more likely than out-of-state travel, a minor might break down and tell her possibly unsympathetic parents about her pregnancy, believing that she has no realistic alternative, while the unwelcome involvement of parents may turn out to be advantageous for some minors. Others might confront abuse upon disclosing their pregnancies or find themselves compelled to carry an unwanted or risky pregnancy to term. Worse yet, a minor may resort to self-induced or illegal abortion. It may seem hyperbolic to raise the specter of such a dire outcome, yet the American Medical Association warns explicitly of this eventuality. And this is the problem in a big way. It's one of the things that has made me, on the side of the abortion debate that I find myself on. Short of resorting to such desperate measures or abandoning her quest for a bypass, the determined minor may find herself trying to travel to another county for a hearing. A minor may be told to contact an abortion clinic, might reach one that is ready to assist her through the bypass process, but she would be likely to discover, as we did, that assistance would only be available in the county where the abortion is performed. Likewise, a minor giving a 100% guarantee that the judge would deny her petition or at best go to another county But even in these instances, the minors' efforts might be thwarted. Courts and employees willing to handle bypass requests have been known to encourage minors to persist in their home counties as part of frustration about judicial unwillingness to implement the law. One Alabama attorney who has represented several minors in bypass cases reports, we had one that came in, called actually about 2 or 3 weeks ago. She had gone to one county to get a waiver of consent, and she said, we don't do this there. So she called one of our attorneys who said, you march your butt crack up there and tell them to have the waiver hearing according to the statute.